Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on our heritage.org website on all of these occasions. For those here in-house, we do ask that courtesy, as our moderator is currently doing, to see that mobile devices have been silenced or turned off. It's always appreciated, especially by the speakers. And of course, for those watching online, you're welcome to send questions or comments at any time, simply emailing speaker@heritage.org. Heritage is pleased today to co-host this program with the Pacific Legal Foundation. Leading our discussion is a former colleague of mine here at Heritage, Todd Gaziano. He now serves as Senior Fellow in Constitutional Law and Executive Director of the DC Center for Pacific Legal Foundation. Please join me in welcoming him. Todd?
Thank you all for coming. Pacific Legal Foundation is also very pleased to co-host this event with our good friends at Heritage, where, as John said, I happily worked for over 16 years. I not only have many good friends still here at Heritage, but Heritage has been at the forefront of the debate over the proper scope and role of the federal government enforcing the Clean Water Act prohibitions. And it also supports groups like us at the Pacific Legal Foundation who litigate to prevent the worst abuses under that act and others. My role is to provide a very brief background for today's discussion, introduce the speakers, and then we'll call on you all before the program ends. So for that background, we'll start with the basics. Pacific Legal Foundation and Heritage are committed to defending individual liberty and the constitutional order. And as those in this room know, the federal government in our Constitution is one of very limited and enumerated powers in the Constitution. Now, it might be a surprise to some outside this room and even some in Congress that the Constitution does not include a clause that allows Congress to prevent all pollution or address all pollution, or it does not include a clause that allows Congress to do all wonderful and necessary things that it thinks it wants. So what is the federal government's power in this area? Well, the federal government has the power to spend our tax dollars for constitutional ends, and Congress does have the express power to regulate interstate commerce. That's commerce between two or more states. So that gave Congress the power to regulate navigable waterways, which include navigable rivers, inland seas, and territorial waters. So the Clean Water Act, which was an historic statute passed originally in 1972, recognizes that limit. So the text of the act is not the problem. The text of the act provides the two federal agencies with jurisdiction power to regulate navigable waters of the United States and other waters of the United States, hence the acronym WOTUS, that stands for Waters of the United States. The act also carefully requires the agencies to cooperate with the states to regulate state waters, or to work with them collaboratively to make sure that all water is clear, but it's quite plain that the federal agencies have neither the constitutional nor statutory power to regulate all water within the United States. So far, so good. But an iron law of the administrative state is that federal bureaucrats will constantly try to figure out ways to increase their power, while they convince themselves that it's for our own good. And thus, the federal bureaucrats over this 40-year period began to creatively interpret their power to regulate navigable waters as to what are navigable waters and what might substantially affect their navigable waters. Now, that led to some Supreme Court cases, one of which my colleague Reed Hopper won. I'll describe in a minute. And that victory of ours led the agencies to their new creative, controversial rulemaking 2 years ago, where they illegally attempted to circumvent the Supreme Court decision. Now, that's my background. I'll let our speakers take it from there. Like me, they are all trained lawyers, but we agreed to keep the legalese completely out, or at least to explain any legalese that we think is necessary for the discussion. And with apologies to them, I'm going to keep their introduction somewhat short, but there is some relevance to today's topic that I want to include. Amanda Aspator is the Vice President for Water, Law, and Policy at the National Mining Association here in Washington, D.C. She will speak first. She represents the mining industry on environmental, administrative, legal, regulatory, and policy issues with a focus of those arising under the Clean Water Act and the Safe Drinking Water Act. Amanda's portfolio also includes environmental justice, public lands, and finance issues. She also serves on the steering committee of the Waters Advisory Coalition. Now, she's going to describe essentially what the rulemaking process currently is in the agencies, what we have to look for at the different stages of that process, and hopefully how we might encourage the agencies to prevent overreach during that process. Now, my Pacific Legal Foundation colleague, Reed Hopper, far to left, but to your far right, will speak next. He is a senior attorney in our environmental law practice group. He oversees our Endangered Species Act project as well as our Clean Water Act project. Now, of special significance today, he is the winning oral advocate in Rapanos versus United States in the Supreme Court in 2006. That overturned one of the outrageous interpretations of the Clean Water Act and led the agencies then to come up with this illegal circumvention of the Supreme Court decision that we've been bedeviled with the past few years. Reed also won another Supreme Court case 2 years ago under the under the Clean Water Act. That involved court jurisdiction or court access for to challenge individual determinations of federal jurisdiction under the Act. And also of interest for this week, he is a lead attorney for a coalition of landowners and other small businesses in several states in a case that will be argued tomorrow. That's a consolidated group of cases, so Reed will not argue this third time, but he did participate fully in the briefing for our clients, and he has been advising the lawyers who will argue. Reed is going to concentrate on what he thinks a legal WOTUS rule would look like, and hopefully talk a little bit about that case. And finally, our third speaker is Darren Baxt. He may need no introduction in this, his home, but we're all indebted to him as leader of the WOTUS working group. Darren is the research fellow in agricultural policy here at Heritage. In that position, Darren studies and writes about agricultural and environmental policy, property rights, among other issues. And he's done extensive work to help reframe the debate on the Farm Bill, and he's hinted to me that he thinks that may have some relevance. We'll see if we can induce him to speak up on its role. Darren is also on the Federal Society Environmental Law and Property Rights Executive Committee and was a member of the Energy, Environment, and Agricultural Task Force of the American Legislative Exchange Council. He's going to focus on what Congress can and should do to help define the waters of the United States. So with that, Amanda, we'll invite you to give your opening.
Thank you so much, and thank you everybody for coming. I know it's been a long weekend and it's hard to come back to work after that. I did one time get interrupted with a cell phone where the ringtone was actually a frog chirping. And so if that's your ringtone, turn your phone back on because it was amazing. So I was asked to give a little bit of background as to what the kind of current status of the WOTUS rulemaking is. And so basically, to bring it back just a little bit, the Supreme Court has chastised both the Army Corps of Engineers and EPA multiple times that they need to really clarify what waters are covered by the Federal Clean Water Act and what waters are left specifically to the states to regulate. And so the 2015 Clean Water Rule, or WOTUS rule, whatever you want to call it, was the Obama administration's attempt to do just that, to provide more clarity. But I think when most of us read the final product of that rule, we looked at it similarly to how I think my gym teachers always looked at me on baseball day, which was, you tried, but you didn't really provide any clarity. And there were some we would say pretty significant legal and policy issues with that rulemaking. And so I think indicative of that is the fact that 31 states, a whole host of industry, ag groups, even the NGOs, all filed suit against the rulemaking. That's not a great sign that you got it right. And then the Sixth Circuit Court of Appeals actually took the step. I know we're not supposed to get into legalese, but it's very rare for an appellate court to stop a rulemaking from being implemented before they've actually ruled on the merits of it. But that is exactly what the Sixth Circuit did. And to do that, they had to find that all of those challengers to the rule, NMA was one of them, these folks were more of them, had a substantial likelihood of success on their claims. So basically, that's the Sixth Circuit Court of Appeals saying, ooh, this doesn't look great for you, 2015 WOTUS rule. And so the current state of play is the regulations that were in place prior to the promulgation of the 2015 WOTUS rule, including the guidance documents that are being used to implement that rule, particularly the 2008 guidance document. And so in July of 2017, this administration proposed to rescind that 2015 WOTUS rulemaking. And basically, they indicated that it's going to be step one of a two-step process. Step one, rescind the problematic 2015 rule. Step two, try again, part two, to redefine what waters of the U.S. is in a way that provides clarity to the regulated community and stands up in court. Just a quick note, the agencies are currently accepting comments and recommendations on what a new rule should look like through November 28th, I believe. And they are holding public meetings once a week, I think it's every Tuesday, for specific groups of stakeholders. And you can sign up for all of that on EPA's website. So I would encourage you to do that if you have an interest in this rulemaking. But back to the proposed rescission, these guys are going to be getting more into the legal aspects without sounding like lawyers, I guess. Good luck with that. But the proposed rescission is more focused on a policy consideration. And so I kind of wanted to walk through that for a second because I think it really shows the impacts that it has on, I know, the mining industry and a lot of other folks who utilize land in this country. And so basically, from best I can tell, the primary driving force behind the 2015 rule was this desire to make sure that the agencies basically asserted jurisdiction through that rulemaking over any water that they thought in the future they might want to have jurisdiction over for whatever reason, because of its hydrologic importance, biological importance, what have you. And that overriding policy consideration, I think, caused them, this is my personal opinion on it, to really shut out a number of other very important policy considerations and the law. But they'll get into that part. I'm focusing on the policy part. And so one of the primary reason that the agencies in the proposed rescission gave for rescinding the rule was that it really failed to acknowledge the policy outlined in the Clean Water Act itself, 101B, to recognize, preserve, and protect the role of the states in protecting land and water resources and determining how they're used. And I think that actually that's definitely one of the major concerns with it, but I think that it also shut out a number of other really important policy considerations. Number one, it did show a complete lack of faith in the states. And they have very comprehensive programs. Our members operate pursuant to lots of them all across the country. And so it seemed a little harsh that there was sort of this assumption that if the federal government doesn't regulate it, the states will just say, meh, I'm sure it's fine, do what you will, because that's not what actually happens on the ground. One of the other issues is it really, if you look at the Clean Water Act permitting programs, the NPDES program and the 404 dredge and fill program, it really does not make sense to superimpose those programs on these marginal water features that would be jurisdictional under the 2015 WOTUS rule. And so, I think just to give an example that folks that don't really deal with those permitting regimes a lot might understand, there are these strict requirements that water quality criteria be applied to all waters of the U.S. How much sense does it make to apply a water quality criteria designed to protect, fish ovaries, which that's a thing, by the way, to a drainage ditch that has never had a fish in it and will never have a fish in it? It doesn't really work on the ground when you don't consider those types of things. Another one is a lack of clarity over a statute that imposes strict liability on people that violate it. And with that liability comes significant civil sanctions as well as potential criminal sanctions. They can throw you in jail. That's a huge, huge problem for businesses, for landowners everywhere. First of all, it causes a lot of delays because you can hold up a project and the jobs that project would create. Just by one example my member had was getting involved in a 3-year argument about whether or not a 404 permit was needed for an abandoned drainage ditch. Really? That's where the Clean Water Act has gone. Another one is actually one that the agencies did try and address in the 2015 rule. It's just unfortunate because, again, that policy consideration of not wanting to accidentally take out waters that they wanted to have jurisdictional caused them to not do it well was on-site waters. Our water features on site are designed to actually protect downstream water quality. Great, we're going to exclude those in the 2015 rule, but we're going to say they're only excluded if they were created on dry land. Okay, what do you mean by dry land? Everybody knows what dry land is. Great, can you put a definition in the rule of what dry land is so we know which features are excluded? There's no commonly accepted definition of dry land, so no. I read that and I was like, I think I just got Jedi mind tricked. I have no idea what that actually means. And so that's another huge issue. And then the one other thing I would note is having that kind of view of federal jurisdiction can actually harm the environment. And I say that because mining companies do a ton of reclamation work as part of modern mining. And sometimes they will go to older mines that existed prior to environmental regulation. They will remine it because it's a more efficient process. But with that will come all of the reclamation activities that you get from modern mining. And so what was once kind of an abandoned area with nothing there could become, a salmon spawning stream or, great wetlands, things of that nature. Well, my member companies aren't going to do that if you're calling the puddles that were there before they went in to remine jurisdictional waters of the U.S. You've just made that not economically attractive anymore. And so you've actually cut off some environmental protections for really no good reason. And so we support rescinding the rule since we don't think it really got it right. And then kind of in the interim, what will be in place is the rules that are currently being implemented because of that stay I told you about, the pre-2015 regulations and the 2008 guidance that implements it. And I was asked to say, are there any problems with that regime? Yes, there definitely are. Not as many as with the 2015 rule, but I'll just close by saying I think one statistic really sums it up well in terms of whether status quo is great either. In the US, it takes on average 7 to 10 years to get a mining permit, to get a mining project permitted. In Canada, which is not exactly known as an environmental destroyer, 2 to 3 years. So we have some permitting issues that we do really want to get addressed, and we want to get it addressed in a way that really is true to the text of the Clean Water Act and good policy decisions that take into account all the important competing policies.
Thank you.
Good afternoon. It's a pleasure to be here. I don't think it's an exaggeration to say that the WOTUS rule issued in 2015 is arguably an expansion of federal authority of the largest nature in the history of the nation. Quite literally, it covers virtually all waters and much of the land in the United States. As proof of that, the WOTUS rule excludes expressly puddles, and just think about that for a second. A regime so broad that it has to exclude expressly puddles, I think is very telling. Let me just tell you what the beef is with the WOTUS rule as it came out in 2015. As was indicated, Amanda mentioned that the rule was assailed immediately by a wide group of individuals, 31 states. We had 70 individuals and organizations that have filed suits. We at the Pacific Legal Foundation represent 11 different organizations from 7 different states. The environmentalists filed suits against this rule. In any event, this ended up in 11 different district courts, ultimately in the Sixth Circuit Court of Appeals. But you may ask what exactly was the concern. Falls into 2 categories. Most of these plaintiffs, including ourselves, challenged the rule for procedural violations. What that means is that the agency did not properly follow the rulemaking process. Let me give you an example. The final rule did not look like the proposed rule. And that means that the public did not have an opportunity to be noticed and to comment on those differences. Some of those differences included the fact that in the final rule, the agency redefined what it meant to be, what adjacent meant. Adjacent wetlands, adjacent waters, those that are abutting or contiguous or neighboring, tributaries and other waters are covered. They redefined that term to mean something more, to include any water within 100 feet of the ordinary high water mark, or within 1,500 feet of the high tide line, or more importantly, within the 100-year floodplain. You can imagine, just think about that throughout the country. This is where land itself, dry for 99 years, would be covered by the Act. Other waters were included in the final rule that were not included in the proposed rule, which would have encompassed isolated water bodies, which the Supreme Court said could not be regulated in 2001 in a decision called Swank. And then also they redefined what the term significant nexus means. In the Rapanos decision of 2006, there was a split among those who ruled in favor of the landowner, Rapanos. We had 4 members of the court, authored by Justice Scalia, writing a plurality that said that the agencies could not regulate tributaries, could not regulate all wetlands except those that are abutting and indistinguishable from covered waters. And then we had Justice Kennedy alone, who put forward a unique and different theory for determining federal jurisdiction. This was called the significant nexus test. And in that test, he said, look, you have to demonstrate that the waters you're covering actually have a substantial effect on downstream navigable waters. But that was changed. In this WOTUS rule, all that was necessary is for the waters to have an effect, essentially, on a water or even a biological or chemical aspect of the aquatic regime. They included 9 different factors that could be considered to establish significant effects, including such things as if the water body holds waters, then it has a significant effect on downstream navigable waters. If it releases waters, it has a significant effect on navigable waters. So it's rigged. No matter no matter what you look at. If you aggregate all waters, you're going to show or be able to demonstrate a significant effect downstream. In addition to these procedural challenges, then there were some substantive challenges that were brought to overturn the WOTUS rule. For example, the WOTUS rule asserted jurisdiction, essentially tried to federalize these waters, among them being that all interstate waters. Now, in the Scalia plurality opinion, he remarked that for over 150 years, it has been the case that we have never allowed federal regulation of all interstate waters unless they had a connection with interstate commerce. They also asserted in the WOTUS rule that all tributaries would be covered. This is a slap in the face to the Supreme Court because it literally undermines the Rapanos decision. In the Rapanos decision in 2006, all 5 justices, the 4 in the plurality, Justice Kennedy, expressly said that the agencies could not regulate all tributaries. It simply went too far. And that's exactly what the WOTUS rule does. In addition, it encompasses, as I mentioned before, isolated water bodies. Here again, slap in the face against the previous jurisprudence of the Supreme Court. In 2001, in that Swank decision I mentioned, Supreme Court expressly stated that the federal government could not regulate isolated waters. And there are many other problems with this as well. Let me just mention 2 others, though, that are of great concern. And that is, in addition to there being a procedural problem with the WOTUS rule, in addition to there being a conflict with the Supreme Court decisions interpreting the Clean Water Act, as well as the text of the act itself, there are constitutional problems associated with the WOTUS rule. And in particular, I would draw your attention to the 2001 Swank decision in which the Supreme Court said that if the agencies had the authority to regulate local ponds and mudflats, it would impinge unnecessarily and inappropriately on the powers of the states. Amanda already mentioned that in the Clean Water Act itself, Congress expressed its concern about protecting the rights and responsibility of the states to control and regulate local land and water use. And that was upended in the WOTUS rule. They simply ignored that limitation. Also, in the Swank decision in 2001, the Supreme Court said that if you regulate this far, if you're regulating local waters, then that raises a Commerce Clause concern. As Todd mentioned, a lot of people don't understand that the Clean Water Act and all of our environmental laws under the Constitution are not expressly authorized by any, specifically titled or enumerated power. So Congress decided to rely on the commerce power as the basis for regulating the environment. So whenever the Congress is regulating a pond or puddle or a ditch, it must do so to advance commerce. And of course, that's obviously not the case. So there's a clear violation there under the WOTUS rule of this constitutional limit. To add a little color to the problems associated with the WOTUS rule itself, I would just mention that subsequent to the rule coming forward, there were some memos that were leaked from the Corps of Engineers that indicated that individuals, scientists, also engineers, hydrologists within the Corps itself disagreed with the EPA and were uncomfortable with the rule, and specifically said that they would not support the rule because it was scientifically and legally unjustifiable. In addition, the GAO did an audit and determined that the EPA had engaged in improper campaigning for the rule to jimmy up support for it. They called it illegal propaganda. So the result of all this challenge was, as Amanda mentioned, that we had the rule stayed in 2 different courts. In the District Court of North Dakota, the judge there issued a preliminary injunction. staying the rule that covered 13 states, which challenged the rule in that jurisdiction. Essentially coming to the conclusion that on its face, it's likely that the rule could not be sustained, that it would necessarily be overruled. And then in the Sixth Circuit, the same conclusion was reached. A preliminary injunction was issued. The court in that case agreed with us that there were probably statutory, procedural, and constitutional violations that would be recognized if the court were to rule on the merits. So we have 2 courts, 4 judges who have agreed with us that this is an illegal rule and that the agency had overstepped. Now, let me go to the second aspect of what I've been asked to talk about, and that is, if this is what we have now, this WOTUS rule, what do we replace it with? What should a new rule look like? Well, the first question that we have to ask is, which is the controlling opinion in the Rapanos decision? That's what we're trying to do. They're trying to implement the Rapanos decision. Or, as Todd mentioned, they actually weren't really trying to implement that decision. They were trying to undermine it. And they did a good job of undermining it. They simply brushed it aside. But the question is, when you have a split decision, like we did in this case, you have 4 justices saying one thing, you have 1 justice saying another, 4 justices saying another, which is the controlling opinion. And the half a dozen or so appellate courts that have looked at that have come to differing opinions. Some of them have concluded that Justice Kennedy's lone opinion is controlling. Some said, well, we really can't decide, so what we're going to allow is you can either follow the 4 justices in the plurality, the opinion authored by Justice Scalia, or you can follow the opinion issued by Justice Kennedy. So that's not very helpful. If you go with the Kennedy approach, you've got one man deciding the law for the entire nation. If you go with the courts who decided you can go with either approach, you have inconsistent application and enforcement of the law, not only from region to region, but within a specific region itself. So those are all really inappropriate approaches. I just completed a law review article called Running Down the Controlling Opinion in Rapanos, which can be found on ssrn.com. And in that, I argue that the only appropriate opinion to follow is the Scalia opinion. That's the plurality opinion. And how do I arrive at that conclusion? In 1977, the Supreme Court issued what's called the Marsh decision. In that decision, the Supreme Court said, look, if you've got a split decision, then what you look at are just those opinions that agreed in the outcome. We have 5 justices, 4 in the plurality, Justice Kennedy and Rapanos. They all agreed that the agency went too far in regulating all tributaries in the Rapanos case. But how do you decide which of those 2 is going to be controlling? And the court says you look to see which is the most narrowly drawn, defined as whether one is a subset of the other. Now, the dissent in Rapanos said if you look at the Scalia plurality and you look at Kennedy's opinion, then the dissent said in almost all cases, whenever Justice Scalia would find jurisdiction, Justice Kennedy would agree. So that means that the plurality decision is a subset of the Kennedy decision. The plurality decision is very narrow, and Kennedy's significant nexus test is very broad. So just a simple application of the Marx test would lead to the conclusion that the Scalia decision should be controlling. And this is one of the things that was mentioned in President Trump's directive executive order for directing the EPA to reconsider and revise the rule. He didn't demand that they rely on the Scalia plurality, but he did require that they give it due consideration, which up to this point had not been given. I think in addition to deciding just which of these opinions is controlling, we also need some sort of a bright line rule. This is probably only going to come in a legislative fix, not a regulatory fix. Nevertheless, we have to deal with what we've got. Also, I think it's important that we stop using these unreviewable internal guidance documents. In addition to that, I think it's important that we make sure that there's fair notice to the individuals who are going to be regulated. The jurisdictional determination program needs to be beefed up. Also, we need to get away from this dual agency approach. Right now, if the Corps of Engineers tells you that you do not have jurisdictional waters, you don't need a permit for your project, the EPA can override that. And that's not a defense. If you acted on the Corps' claim, it's no defense to you. You can still be prosecuted civilly and criminally for your action after years later, after the EPA is saying we simply disagree. Also, I think that what's important is that the agency show some restraint, regardless of what rule is actually adopted. It's not going to matter much if the agency doesn't show some internal restraint and get away from its overzealous enforcement of the act. So to sum this up, let me just say that I think a proper rule should be very simple, and I would suggest to say something along this line, that it covers traditional navigable waters that are subject to and capable of use in interstate commerce, that it covers permanent, uninterrupted, continuously flowing rivers, lakes, and streams, and that it cover wetlands that abut and are indistinguishable from those waters. That's simple. 3 paragraphs, that's it. That's what I would do. And I think it achieves all those goals that I just outlined. Now let me just conclude with this one final comment that Todd mentioned that tomorrow the Supreme Court will be hearing a case on this issue. There are 2 aspects to the WOTUS challenge, and one has to do with the validity of the rule. That question is on hold in the Sixth Circuit Court of Appeals, as Amanda has said. But the other question is, where is the proper venue for bringing such a challenge in the first place? And that's been the bone of contention for several years now, as we've been trying to litigate this question. Now, the language in the Act seems to us to be quite clear. And it suggests that only under a limited number of circumstances should the original challenge be brought in a court of appeal. The EPA takes the position that the WOTUS rule, that's a jurisdictional rule that defines the scope of the act, is comparable to issuing an effluent determination or an NPDES type permit, and therefore should be heard directly in a court of appeal. The problem with that is that it allows individuals only a 120-day statute of limitations. Most people won't even know. You mentioned, Amanda, that it takes 7 years to get a permit. You may not even be ready to file a complaint or challenge the rule for years to come. We think that the proper reading of the rule requires that challenges to the jurisdiction of the agency should be brought in the district courts. And this allows a statute of limitations of 6 years. So the agency, the question before the Supreme Court tomorrow is whether the statute authorizes these types of challenges to be brought first in the district court or in the appellate court. And it's simply going to be looking at the language of the act. And almost all the parties agree that as written, we are correct that it suggests that you first bring the action in a district court. The EPA is really relying on a policy argument. Their argument is that, hey, it's going to be more efficient. It's going to be easier for us to defend one challenge in one court rather than multiple challenges in multiple courts. And for that reason, the court ought to go with their interpretation. We think that that is simply unacceptable in an orderly society, and those who are regulated need to be able to rely on the plain text of the act. Now, I just want to emphasize that this may seem like an esoteric argument. That we're simply looking at venue questions, but this affects literally millions of individuals across the country. Since the 2006 Rapanos decision, the agency has considered 400,000 jurisdictional determinations and issued over 120,000 specific jurisdictional determinations based on the Kennedy approach. So this is critical to establishing access to the courts for the average landowner. Now, and this is not going to be mooted. Even if the agency were to withdraw the rule today, it still makes sense for the Supreme Court to issue an opinion on which court has jurisdiction to hear these challenges. And I'm sure it will, no matter what happens with the rule. Now, when the rule is issued, it is almost certain to be challenged. And even we may challenge it because it is likely that it will not be acceptable to us, that it goes too far and is too broad. And no doubt the environmentalists will argue that it's shrunk and it hasn't gone far enough. Either way, we're going to be back in court. Hopefully there'll be enough time for that to work its way through to the Supreme Court and get a final decision on that. Whatever it takes, we at Pacific Legal Foundation will be there to defend property rights.
Thank you. Thank you for being here. When dry land is regulated as waters of the United States, it's a problem. When tire ruts are considered waters of the U.S., that's an issue. When a farmer is plowing land and basically the Corps deems the little furrows to be small mountain ranges, that's an issue. Trump administration should be commended for their actions to get rid of the WOTUS rule. But even if the Trump administration comes up with the best rule in the history of rules, a future administration that's set on expanding federal power can always get rid of that perfect new rule. Therefore, we need Congress ultimately to define what navigable waters actually means. So how should Congress define navigable waters? So navigable waters, we've heard in the Clean Water Act, covers territorial seas and waters of the U.S. So before getting into kind of my specific definitions, I think there are certain factors that should inform us in coming up with a definition. First of all, we're talking about coming up with new statutory language. We're not bound by the case law or regulation or anything. We can come up with what we think is actually sound policy. And actually, Congress is authorized by the Constitution to actually adopt the language. A major theme that's been addressed today is the fact that the Clean Water Act, right out the outset, says that a primary role of the states is to protect the water quality and to protect against pollution in waters. The states don't have a supporting role when it comes to the Clean Water Act. They have a primary role in it. So if the federal government is regulating pretty much every water you can imagine, well, the states aren't going to have much of a role, and there's something wrong with that. And the Supreme Court, both in the Swain case that was mentioned and Rapanos, brought up these issues regarding this kind of federalism angle. When the EPA is a local zoning board, that might implicate the Constitution. We need an objective definition. If you're trying to comply, you're a property owner, and you're trying to just comply with the law, and you have no idea what the law even means, it's pretty hard to comply with it. The language is subjective and vague. The WOTUS rule wasn't. Even before that, the language is subjective and vague. So it's really hard to be able to know whether or not you're complying properly. And when the Corps says, okay, you can have a permit, and then the EPA, after the fact, comes up with a retroactive veto and says, "Now, sorry, that's something that needs to be addressed. This retroactive veto that the EPA has. If a water, and this is kind of suggested in the preamble of the WOTUS rule, the WOTUS rule would have covered waters that may not even exist anymore. So you may have on your property be building something, and it turns out you're going to get in trouble not because you can see a water and you're messing around with some water, but the EPA or the Corps had done some satellite imaging and found out that some water existed there in the past. I don't know that many property owners that have airplanes to go fly around and do aerial photographs. And I don't have a satellite to do satellite imaging. And unfortunately, the EPA or the Corps would actually figure out that a water is jurisdictional as a result of that. The problem is that the ordinary person is not going to be able to comply with the rules as they're drafted. So any type of new language, any definition of navigable waters needs to be clear. But it's beyond just the ordinary person that's not going to be able to comply. The experts don't know whether or not something is actually a waters of the U.S., whether or not it's jurisdictional. You could have somebody in one region look at a water and say, that's not jurisdictional. Somebody else say something completely different. Now, the reality is this vague nature of the rules are really done on purpose. It's not an accident. It gives them some flexibility to be able to kind of decide, in the future whether or not they want to deem something to be jurisdictional. By jurisdictional, I mean that the agency can regulate the water, require a permit. If you don't know how to comply with something, under the Clean Water Act, you don't have just civil penalties, you have criminal penalties. And as my colleague Paul Larkin has written about extensively, that also has constitutional implications. Imagine going to jail over something you have no idea it's like a Kafka type of novel type of thing. So if we have objective language, the definition, and it's more narrow, the definition of what waters of the U.S. means, I actually think that's good for the environment because the regulated parties know what to do and the regulators know how to regulate, and they can focus their resources best on what's actually needed to be regulated. And I'm not sure if I'm going to use this line properly, but we need to stop worrying about the zebras and focus on the horses, something like that. All right, so what are the waters that should be the navigable waters under this new amended Clean Water Act? Well, you've got the territorial seas, so now what we're going to do is look at the waters that would constitute the waters of the United States. And Reed kind of laid out, I think, what there would be. There are three types of waters I would have. Usually, the water that the primary water people think about is the navigable, in fact, water. And they look at the language from like the Daniel Ball case from 1870 and the progeny of those cases. But even in those cases, it's not clear, well, they're not necessarily interstate in nature. So we want to make sure that the statute is grounded in and authorized by the Commerce Clause. So it starts with the Commerce Clause. So the first water are interstate waters that are used or susceptible to use to transport interstate or foreign commerce. So one, interstate, the water itself crosses state lines. And also, some of the navigable in fact language would actually look to waters that in the past used to have interstate commerce across the state lines. But I'm not looking to the past here. It's either it needs to be used for commerce now or susceptible to use. So these are the main waters. Everything starts with these interstate waters used for interstate commerce. Then we would look at tributaries to those particular waters. And here's where language would come pretty much directly from Justice Scalia in the Rapanos case. I'm just going to read it. It's basically his language. So we're talking about relatively permanent, standing, or continuously flowing bodies of water that form geographical features known as streams, rivers, and lakes that flow directly into those waters, the waters I just talked about, those interstate waters. So the question the EPA and the Corps have posed, and others have posed, is what do we mean by these relatively permanent? What does that mean? Well, in footnote 5 of Rapanos, Justice Scalia kind of answers that question. And I'm going to just follow that. I'm not very original. I'm just going to follow him. The water would have a continuous flow for at least 290 days of the year, except due to extreme events such as droughts. So I've answered that. And then it would cover wetlands. That would, now we saw the problem with being adjacent. The EPA and the Corps, when adjacent doesn't really mean adjacent, doesn't mean abutting, it means whatever they want it to mean. In Rapanos, Scalia talked about the idea of you can't tell where one water starts and other ends. So the wetland would have to have a continuous surface water connection to either those interstate waters or the tributaries. And I add a little component here. So what does it mean to have a continuous surface water connection? Well, to me, that means a connection which an ordinary person would not be able to visually determine by the naked eye, by looking at the water surface, where one body of water ends and the other begins. So I've added this kind of ordinary person, naked eye standard. Now, while these three definitions are important, maybe what's even more important, if Congress ever does amend the Clean Water Act and the definition of navigable waters, is the actual exclusions, what the waters are not. So I want to cover intermittent or ephemeral waters. Look, if you have a depression on land that holds water 2 days out of the year after a heavy rain, but other times of the year it's just dry land, that shouldn't be a water of the U.S. Man-made ditches, nope. Under the WOTUS rule, the EPA and the Corps wanted to be able to combine waters together. So the water itself wouldn't necessarily meet the definition of waters in the United States, but in the aggregate, if you take this water and this water and that water and this water together, they meet the definition. Well, I don't think you should be able to take 10 puddles and combine them together to equal wetland. So the water itself should actually meet the requirements. And very simply, if an ordinary person, with their naked eye, can't determine whether or not a water is covered, then it shouldn't be covered. It shouldn't be a guessing game. Look, the administration is doing what it can right now to protect the environment while respecting the law, states, and property rights. Congress, though, ultimately is going to need to do it as well, and I hope that they will soon.
Well, thank you all, and I think I may just ask one moderator's question and then turn to the audience, so think about your actual question. And that was, Darren, since you hinted that you thought there might be a congressional path, that I think we all would agree that a great definition in statute would be close to the Holy Grail. So now just tell us how that will get done in Congress.
No idea. Look, I think it'll be really difficult for Congress to address it through standalone legislation, so you need to find must-pass legislation. And so a big theme in our agriculture work with the Farm Bill is to address a lot of regulatory issues, and I think it's a very appropriate legislative vehicle to address water issues through the Farm Bill. So, and the Farm Bill is, the programs are kind of up in 2018, so the Farm Bill will likely, well, if it's on schedule, it would pass in 2018, but who knows? But so Farm Bill,
A nice, non-controversial election year
right?
rider to a Farm Bill. Okay, sounds good. Well, that's one path. Let's make sure Darren gets it done. Okay, now I will call on your questions, and if you don't have them, be warned, I have some extra. But I think we will have someone here from Heritage. I'm waiting with a microphone and calling on our Heritage friends for that microphone. But if not, I'll call on Dawn first, and then maybe I'll echo your your question for the millions who are watching the webcast and the millions more who will watch the archive footage. Oh, here it is. Okay.
All right, Don Parrish, American Farm Bureau Federation. Short of Congress moving legislation in 2018 as a part of the Farm Bill, I would be interested from Reed and Amanda. We are in the midst of a rulemaking. And Reed, specifically, when you put forth a litany of reasons why the 2015 rule was bad, do you think the administration articulated those concerns when they proposed a rule to rescind this rule?
Well, I think that I think there's room for cautious optimism. When the agency put forward its proposed interim rule, it said some things that I think were encouraging. For example, it indicated that it was going to look at competing values and recognize that the decision on where to draw the line for jurisdictional waters cannot rely entirely on the hydrology. We also have to factor in the economy. We have to even factor in the legal consequences because, as we just talked about, there are statutory and constitutional limitations on federal power. They also recited in that proposed interim rule that they recognize that in the WOTUS rule, the agencies had not factored in the federalism concerns and the rights and authority and responsibility of the states. On the other hand, the cons with respect to that is that they concluded in that proposal, which reinstates the rule that brought us to this pass, that there were no federalism concerns. So they're kind of taking away with one hand what they give with the other. They also rely on the guidelines from 2003, which was supposed to be an interpretation of the Swank decision, which is invalid on its face, I believe, not only because it was never fully adopted under the rulemaking process, should have gone to Congress under the Congressional Review Act, gotten approval there, but it simply misrepresents the case and limits it to its specific facts. In other words, the 2003 Swank guidance says we can regulate isolated waters as long as they're not based on migratory birds. That's a gross misreading of that decision. Same thing with the 2008 guidelines, which purportedly interpret the Rapanos decision. Again, as I said, the 5 justices in Rapanos expressly stated that the agencies could not regulate all tributaries, and that's exactly what the interim rule does. So I think the interim rule is going to be a basis for the new rule. I mean, I think it's going to be a baseline. They may improve on it a little, but I'm not optimistic that they're going to throw it out and start from scratch and really give us what we want. Does that answer your question?
Myron Ebel, CEI. That was great and it was clear, but there's still some murky areas in my mind on these things. One is and you alluded to this, but the fact that each court case can somehow be treated separately. That you know, a landowner here gets a decision, but then the agency says, "Oh, but this one's different," you know, even though it appears to be identical. And we have a lot of people who've been caught in this system for a long time. And I'm wondering if anything can be done through the new rule or through congressional enactment that could look back at the people who have been caught in the system and also end this practice of treating every single decision as separate from, it's somehow different because it's a different piece of land, and we can ignore these court cases and these previous decisions.
That's one of the reasons why this case tomorrow is so important. If we prevail in our argument that challenges to jurisdictional rules under the Clean Water Act can and should be brought in a district court with a 6-year statute of limitations, that means we have 6 years to make a facial challenge to the rule, as opposed to an as-applied challenge or a case-by-case determination. If the agency wins on their interpretation that you got to bring these up within 120 days in a single court, then we're going to have a hard time, challenging facially these rules. We're going to have to go case by case. Let me just add one more thing. In 2004, the GAO did an audit of the core practice of determining jurisdiction and determined, as Darren had said, that the agency purposely uses ambiguous language. What's a discharge? What's a wetland? What's adjacent? So that it can apply a different interpretation, a broader interpretation on a case-by-case basis. And that's exactly what you're saying. And so a landowner who's aggrieved by that, they go to court and they win, but because it was a case-by-case determination rather than a global application of a jurisdictional determination like we have with the WOTUS rule, the agency can literally lose the case, walk across the street to your neighbor, and apply the same rule that it just lost on, saying that's a new case, different facts, new rules, and you're back where you started. So I really think that the answer, again, doesn't lie with a good rule. It's got to come from the legislature. The bright line has to be in the act. Because even if you have a bright line rule in the regulation, the enforcing officers don't follow it. We know that.
One thing I would just add from a practical standpoint is that jurisdictional determination, so the official determination from the agencies as to whether or not you have a WOTUS on your property, lasts for 5 years. And so to the extent that you got a quote-unquote bad JD, a JD that you disagree with, if you do have a bright line rule that has longevity, you can get a JD done under that new rule.
JD, jurisdiction, glad you defined that.
Jurisdictional determination, yeah.
Good, okay. I think we started a couple minutes late, so we have time for perhaps one more. Who wants to ask the last question? I think we can end on time then. I want to thank our presidentially nominated, pending Senate confirmation, Heritage, Cully Stimson. No, he doesn't want me to thank for carrying around. That's one of your highest remaining duties before the Senate confirms you, Cully. And please join me in thanking our panelists for their discussion.